This is Michael Popak, Legal AF. We just got a great example by Judge Mershon in Manhattan, New York State Supreme, of how you comport yourself with your ethical requirements once challenged. We know that Donald Trump moved to disqualify Judge Mershon. The motion to disqualify and recuse himself is pending. He makes that decision, as all judges do in the first instance. Sure, there's a court of appeals above him and another appellate division above him, but he makes the first call the way all judges do. And what I found really great about the fact that the Manhattan DA and Matt Colangelo just filed opposing papers to stop the disqualification or recusal is that we also learned that Judge Mershon reached out to the Ethics Advisory Committee and got an advisory decision back in May that was published. We just didn't know it was necessarily Judge Mershon. Now, when you look at it carefully, you do. But now we look at it, he got advice, and he was told by the advisory committee, you don't have to disqualify and recuse yourself. He listed in a letter, this is how it works. If you're a lawyer or a judge and you have some concern about your own compliance with ethics, you can go to an ethics hotline available by your local bar or bar association. In this case, you can go to the ethics panel if you're a judge, and they will look at your letter and they'll respond to you and they'll give you guidance. And if they think it's really important for others to know about it so that they can use it to guide their own conduct ethically, they'll publish it. And that's what happened. There was a published decision back in May. It is the foundation of what the Manhattan prosecutor now is arguing to Judge Mershon to keep him in the case, which is there is nothing about your conduct, nothing that suggests that it rises to the level of an appearance of impropriety or that you should recuse yourself. So don't. Stay in the case. Now, that's running parallel to another set of proceedings that you may recall in federal court, because Donald Trump not only moved to disqualify Mershon, he's trying to transfer the case over to federal court. It would come along with the same prosecutor. The state prosecutor would go with the case. The state law would go with the case. But it would be tried in a federal courthouse in front of Judge Hellerstein, a Clinton-appointed federal judge. Let's leave that out for a minute. We'll do that at another hot take. That's going to be decided at the end of June or beginning of July by Judge Hellerstein. My guess is he's going to reject the transfer and it's going to stay with Judge Mershon. But give it up to Judge Mershon to reaching out and getting an ethics opinion, which now the Manhattan DA's office can use extensively in their own papers and say, look, Judge, you did the right thing. You went out and got an ethics opinion. The ethics told you that a $35 series of total donations to Democratic causes is not enough to disqualify you. And he literally donated $15 to Joe Biden. And the fact that your daughter, even though she's 1 degree separated from you, works for a Democratic consulting firm, political consulting firm that works for Democratic candidates, even Joe Biden, even Hakeem Jeffries, the future Speaker of the House, that's not enough to disqualify you. And even though her firm, which is well known, Lauren Mershon's firm is well known, was in the running to work with Alvin Bragg when he, the Manhattan District Attorney, was running for election for that position 2 years ago, but they didn't get the job, and Mershon didn't work on that engagement. That's okay too. So that took out most of the arguments that Donald Trump's lawyers, Susan Necheles and Todd Blanche, have raised. They've also raised the fact that Mershon, in their view, was too involved and inappropriately involved in plea negotiations in favor of the Manhattan DA with Alan Weisselberg, the longtime 50-year CFO for Donald Trump and his father, who ended up going to Rikers Island for 5.5 months because he had his own 17-count tax fraud problem as part of the convictions. And they thought, well, he played rough in the chambers and manhandled Alan Weisselberg and forced him to testify against Donald Trump. That's BS. First of all, then you don't understand how the justice works in the Manhattan Supreme Court system, New York Supreme Court system. Judges often take parties into their chambers and either in a civil case or in a criminal case, get involved with helping to negotiate resolutions of issues. At that moment, the Manhattan DA was having troubles getting Alan Weisselberg's lawyer at the time to cooperate with the Manhattan DA and avoid being prosecuted and continue to be indicted. The judge basically said, if you want leniency in sentencing, you got to cooperate with the Manhattan DA. And you got to let me know by Monday because we got a trial starting on Monday. And if you don't like it, you don't have to cooperate with the Manhattan DA. And then I'm going to sentence you if you get convicted. That is just a judge not reading the riot act, just stating the truth. And that is one of their roles, is to mediate and to navigate with the parties, prosecutors and defense lawyers, issues like plea deals, witness cooperation, levels of cooperation, sentencing. That's all part of their toolbox. So to call that out and say, oh, he got unnecessarily involved, Judge Merchan, with the plea negotiations and looked like he was putting his thumb on the scale in favor of the Manhattan DA, that's just a misinterpretation of somebody who doesn't regularly practice in New York State criminal cases. So that is, as the Manhattan DA pointed out, that's not grounds to disqualify yourself. Doing a good job in how you presided over a prior case and handled witnesses. And then if you look at, which I think is really fascinating, having done something like this in my own career, if we look at the actual ruling by the advisory ethics panel in favor of Judge Merchan, you know it's Judge Merchan and Donald Trump, but their names are anonymous because for a number of reasons. One, when you send your letter in, you do put all the details. But when they're doing the advisory opinions, they want the advisory opinions to apply to everybody's conduct. So they try to water it down a bit, not in terms of the facts or the analysis, but in terms of the names. So they make it more universal in application, right? So, but you know in reading it who it is. So this opinion, which is opinion 23-54, meaning it's the 54th opinion of the 23rd, 2023, issued on May 4th, 2023, in its summary says, a judge's impartiality cannot reasonably be questioned based on A, de minimis political contributions made more than 2 years ago, or B, the business and or political activities of the judge's first degree relative, where the relative has no direct or indirect involvement in the proceeding, meaning the criminal trial, and no interest that could substantially affected by the proceeding. As a result, the judge is not ethically required to disclose such facts or circumstances on his own, sua sponte, in the proceeding, regardless of any surrounding publicity or lack thereof. The judge may continue to preside in the matter, provided the judge believes that he or she can be fair and impartial, which Merchan has already concluded. And then they go off on their opinion, and they do say, yes, a judge should avoid the appearance of impropriety, and a judge should not allow family, social, political, or other relationships to sway them, or their partisan interests to sway them. And they shouldn't preside in a matter where their impartiality might be reasonably questioned. That doesn't mean Donald Trump in his social media posts and at rallies bashing the family and bashing Merchan as a Trump-hating judge. It means a reasonable person. So take Donald Trump out of that mix. And then it just goes on to talk about the $35 in total contributions political that the judge made to Democratic causes. And they were like, that's so low, that's so de minimis that it couldn't possibly affect your judgment. And then as to the daughter issue, they're like, the daughter didn't even get the gig. She didn't get the job. So how could that be affected by you helping prosecute, and convict Donald Trump because the Manhattan DA happens to be in the room on the other side? I mean, that's so attenuated that it doesn't even come close to creating an ethical problem for the judge. And so in their conclusion, the ethics opinion, which the Manhattan DA cites extensively in their opposition papers they filed, says that we conclude that the judge's impartiality cannot reasonably be questioned based on the judge's relatives' business and or political activities, and the judge was not ethically required to disclose them. And Matt Colangelo, who's gone after Donald Trump before when he worked in the Justice Department, but now in the Manhattan DA, pointed out that opinion and then went off and said, you know what Donald Trump does all the time? He mercilessly attacks judges, jurors, and prosecutors. And then he listed all of them from Donald Trump's social media. Once again, the gift that keeps on giving, which is Donald Trump and his public statements. And so, look, now that that's all in front of the judge. The other interesting thing that came out of recent reporting and based on the docket is that there's 2 subpoena fights that are also in front of Judge Mershon. Manhattan DA wants E. Jean Carroll, the sexual abuse convicted defamation case for Donald Trump back in May. He gave a full-length deposition on videotape in transcripts. Only about 40 pages of that few hundred-page deposition transcript has ever been made public, and the video has never been shown in full. The Manhattan DA wants to see it because it relates back to their continuing investigation about statements that Donald Trump has made denying any sexual relationships with anyone, let alone payoffs related to it. And so there's a fight now because they've subpoenaed E. Jean Carroll's lawyer, Robbie Kaplan, to get a copy of the video and of the deposition transcript, and Donald Trump's side is fighting it because they're saying it's not relevant. Of course it is. And the second thing that the Manhattan DA is subpoenaing is the Trump Organization. Let's get all of your non-disclosure and confidentiality agreements related to women that you've ever entered into, because this shows you how broad this investigation could go. It's not just about Stormy Daniels. There's a broader case here and a broader conspiracy scheme that they're continuing to go after. So they want all severance and confidentiality agreements with women entered into by the Trump Organization or Donald Trump. And they want Melania's emails with Rona Graff, a well-known political operative. So Manhattan DA's office is not done both developing all of the evidence to convict Donald Trump related to Stormy Daniels and to maybe bring a future new indictment, a second indictment related to other aspects of a conspiracy. We'll follow him here on the MeidasTouch network, just like we follow this critical case on a daily basis when there's new events. I do it here, MeidasTouch Network. Also, we do a podcast called Legal AF, Wednesdays and Saturdays. You can follow me on all things social media at MS Popak. This is Michael Popak, Legal AF reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.